Thank you, Mr Acting Deputy President. And I just want to start my contribution by picking up on some of the arguments Senator Lyons put just then. Much of Senator Lyons' contribution was focused on the fact that the particular training provided to Serco employees or employees more generally at these facilities is not sufficient for them to have the training to use reasonable force. She also made the point that the specific changes in this bill were not specific recommendations of the review into the detention centre facilities, the Hawke review, I think it was. Now, I have the Hawke review right here on my trusty smartphone. My iPad's gone dead, sorry, but right here, and I'll have to read this close, sorry, because the text is small, but on page 153 it says the 4-week induction course, this was a course provided by Serco, the 4-week induction course provides a Certificate 2 Security Operations Qualification, as Senator Lyons said, and covers areas relevant to security management at an immigration detention centre, including the use of reasonable force and restraints. Now, Senator Lyons spent most of her contribution saying that this training course doesn't provide people with the skills and experience to use reasonable force. She also said that the review didn't cover the aspects that we're debating here today. Well, it did, and the training does. So Senator Lyons' argument is completely wrong. The training course that is provided by Serco does provide training sufficient for the use of reasonable force, and the review that her own government or the previous Labor government commissioned into these incidents admitted that or claimed that. So I think that's good enough. If it's good enough for a review that Chris Bowen released while he was Immigration Minister, I think it's good enough for us for this bill's purposes. Now, it is true, as Senator Lyons said, the report did not make specific recommendations about the use of reasonable force. What it did say, though, is that the department had to more clearly articulate the responsibility for public order and management between the department, between the detention service provider and any police services. This particular review that was conducted was into 2 particular incidents at Christmas Island and the Villawood Immigration Detention Centres in 2011, some serious incidents that did involve the use of police services. And there had been, and the report outlined, that there were difficulties in transitioning from detention service providers to the police forces in terms of who had responsibility for bringing public order and safety back into some balance. And that's why the review recommended that more clarity had to be provided, and this bill provides that greater clarity. That is what this bill is about. It's about defining that officers, authorised officers at a detention centre employed by a detention centre provider will have the authority to use reasonable force. And it's important to establish or to point out that the employees at the moment can use reasonable force. This is not a new. This bill doesn't establish something new. What it does is provide greater clarity and certainty. Officers right now can use reasonable force. Indeed, my understanding of the common law is most of us could use reasonable force if necessary in our own working lives. The employees of detention centres do need to rely on that common law provisions, though, that provide and allow for the use of reasonable force where a court could look objectively that there was reasonable response in the circumstances. But, of course, relying on the common law doesn't provide officers with the degree of certainty that our police forces would have, and the protections in state acts for them that wardens at prisons would have, and the protections for them. They have protections for the use of reasonable force that are codified and included in the various laws that govern their professions. What this bill does the same. It's saying there is a common law provision, there is a basic right to use force when it's reasonable, but we should provide the employees in these facilities who put their own safety at risk some greater certainty that they too have the protections afforded to other officers in similar roles, particularly those employed by state and territory government. So what does this do? Well, this bill provides specifically and outlines specifically what an authorised officer may use as reasonable force, so it provides that clarity I was speaking about. And in the case that an authorised officer reasonably believes it's necessary to protect a person, including the authorised officer him or herself, in an immigration detention facility from harm or the threat of harm, reasonable force can be used. Reasonable force can be used if it's reasonably needed to protect a detainee in an immigration facility from self-harm or a threat of self-harm, or to prevent the escape of a detainee from an immigration detention facility, or to prevent a person from damaging, destroying or interfering with property in an immigration detention facility, or move a detainee within an immigration detention facility, or prevent action in an immigration detention facility by any person that endangers the life, health or safety of any person in the facility, or disturbs the good order, peace or security of the facility. Those provisions specifically outline with some clarity what officers can do, what officers can use reasonable force for, and that's not something that currently exists for them relying on the common law. And I understand Senator Lyons' care for the welfare of authorised or of officers and employees of detention service providers, but it is my view, and I disagree with her, that these protections are actually all about protecting those employees. It's about providing them with the safety and security that they can act to protect their own safety and the good working order of the detention facilities they work in. It's also the case that while the clarity has been provided in that case for what could constitute reasonable force, this bill doesn't seek to specifically define reasonable force per se. Under policy, reasonable force must be no more than required to ensure the life, health or safety of any person in the facility, be consistent with the seriousness of the incident, be proportional to the level of resistance offered by the person, avoid inflicting injury if possible, and be used only as a measure of last resort. So the explanatory memorandum, what I just quoted, is from the explanatory memorandum, and it specifically outlines that reasonable force can only be used where those criteria are met in accordance with the general policy for the use of reasonable force. And there are a number of protections in there. Now, with this bill, does also introduce other protections. There are requirements there, of course, on officers only to use reasonable force as a last resort and only where it's a reasonable use of that force. But there will also be, this bill also will establish a statutory complaints mechanism that will allow anyone that would like to make a complaint about the use of force by a detention service provider to make that complaint and have that complaint dealt with. Now, it is also the case that this bill is really needed to respond to the fact that Senator Lyons mentioned that there was only 120 people she thought there was a great threat, and only 120 people. Well, 120 people can do a lot of damage. 120 people can disrupt and cause harm to many people. And I actually want to put the interests of the employees of detention service providers ahead of those 120 people that Senator Lyons admits are troublemakers when they're detention facilities. So this bill should be something that's supported and implemented by this government. And, Mr. Acting Deputy President, I would like to seek leave to continue my remarks at a later stage.